The correct answer is D. Quo warranto. Quo warranto is a Latin term that means, by what warrant? It is a writ issued by a court to a person who is holding a public office to which he or she is not entitled. The writ asks the person to show by what authority he or she is holding the office. If the person cannot show that he or she is entitled to the office, the court may order the person to stop acting in the office. Habeas corpus is a writ that orders a person who is being detained to be brought before a court so that the court can determine whether the detention is lawful. Prohibition is a writ that orders a lower court to stop hearing a case. Certiorari is a writ that orders a lower court to send the record of a case to a higher court for review. So, the writ that is issued by the Supreme Court to restrain a person from acting in an office to which he is not entitled is quo warranto. I hope this helps. Let me know if you have any other questions. The correct answer is B. Right to freedom of religion. The right to freedom of religion is guaranteed by Article 25 of the Indian Constitution. It states that all persons are equally entitled to freedom of conscience and the right to freely profess, practice, and propagate religion. This right is absolute in nature, which means that it cannot be restricted or limited by the state. The other rights mentioned are not absolute. The right to equality is guaranteed by Article 14 of the Constitution, but it can be restricted in certain cases, such as for the purpose of maintaining public order or morality. The right to constitutional remedies is guaranteed by Article 32 of the Constitution, but it can be suspended during a national emergency. The right to get equal pay for equal work is guaranteed by Article 39(d) of the Constitution, but it can be restricted by the state for the purpose of promoting economic equality. Therefore, the only right mentioned in the Indian Constitution that is absolute in nature is the right to freedom of religion. I hope this helps. Let me know if you have any other questions. The correct answer is A. Articles 19 to 22. Articles 19 to 22 of the Constitution of India guarantees the right to freedom of speech and expression, assembly, association, movement, residence, and profession. These rights are subject to reasonable restrictions that can be imposed by the state for the sake of public order, morality, health, and other purposes. Article 29 guarantees the right of every cultural, linguistic, or religious minority to conserve its distinct identity. Article 30 guarantees the right of every religious or linguistic minority to establish and administer educational institutions of its choice. Article 32 guarantees the right to constitutional remedies, which means the right to approach the Supreme Court for the enforcement of fundamental rights. Articles 14 to 18 guarantee the right to equality, including the right to equality before the law, the prohibition of discrimination on grounds of religion, race, caste, sex, or place of birth, and the right to equal protection of the laws. Therefore, the right to freedom is guaranteed by Articles 19 to 22 of the Constitution of India. I hope this helps. Let me know if you have any other questions. The answer is D. Fundamental rights. During a national emergency, the President of India can suspend the fundamental rights guaranteed by the Constitution, except Articles 20 and 21. Article 20 guarantees protection in respect of conviction for offences and Article 21 guarantees protection of life and personal liberty. The directive principles of state policy, DPSP, are not fundamental rights and cannot be suspended during a national emergency. The amendment procedures of the Constitution cannot be suspended either. Judicial review is the power of the courts to strike down laws that are unconstitutional. This power cannot be suspended during a national emergency, but the courts can be prevented from hearing cases that challenge the government's actions during the emergency. Therefore, the only provision that stands suspended during a national emergency is the fundamental rights. I hope this helps. Let me know if you have any other questions. The answer is A. Right to property. The right to property was a fundamental right under Article 31 of the Indian Constitution. However, it was deleted by the 44th Amendment of the Constitution in 1978. The amendment stated that the right to property is no longer a fundamental right, but a legal right. This means that the right to property can be restricted or taken away by the state, but only if it is done in accordance with the law. The right to primary education is not a fundamental right under the Indian Constitution. It is a directive principle of state policy, which means that the state is supposed to strive to provide free and compulsory education to all children up to the age of 14 years. However, the state is not legally bound to do so. The right to life is a fundamental right under Article 21 of the Constitution. It states that no person shall be deprived of his life or personal liberty except according to procedure established by law. This right is absolute and cannot be restricted or taken away by the state. The right to information is not a fundamental right under the Indian Constitution. It is a statutory right, which means that it is created by law. The Right to Information Act, 2005, gives citizens the right to access information held by the government. Therefore, the right to property is the only fundamental right that ceased to be a fundamental right and became a legal right under the 44th Amendment of the Indian Constitution. I hope this helps. Let me know if you have any other questions. The answer is B. U.S. Constitution. The fundamental rights in the Indian Constitution are inspired by the Bill of Rights of the U.S. Constitution. The Bill of Rights is a list of 10 amendments to the U.S. Constitution that guarantee certain rights and freedoms to the people of the United States. These rights include freedom of speech, freedom of religion, the right to bear arms, and the right to a fair trial. The Indian Constitution also draws inspiration from other constitutions, such as the French Declaration of the Rights of Man and of the Citizen, the Irish Constitution, and the South African Constitution. However, the Bill of Rights is the main source of the fundamental rights in the Indian Constitution. The Act of 1935 is a British law that was enacted to govern India. It does not contain any fundamental rights. The Russian Constitution is a communist constitution that does not guarantee individual rights. The British Constitution is an unwritten constitution that does not have a list of fundamental rights. Therefore, the fundamental rights in the Indian Constitution have been taken from the US Constitution. I hope this helps. Let me know if you have any other questions. The answer is A. J.S. Khehar. Chief Justice J.S. Khehar headed the 9-judge constitutional bench that declared the right to privacy as a fundamental right in 2017. The other judges on the bench were Justice J. Chelameswar, Justice S.A. Bobde, Justice R.K. Agrawal, Justice Rohinton Nariman, Justice A.M. Sapre, Justice D.Y. Chandrachud, Justice Sanjay Kishan Kaul, Justice S. Abdul Nazir. The bench unanimously held that the right to privacy is protected as an intrinsic part of the right to life and personal liberty under Article 21 of the Indian Constitution. The bench also held that the right to privacy is not an absolute right and can be restricted in certain cases, such as for the purpose of national security or public order. The judgment was a landmark decision that has had a significant impact on the protection of privacy in India. It has been cited in several subsequent cases, including the case of Puttaswamy vs. Union of India, in which the Supreme Court held that the government's Aadhaar scheme was unconstitutional. I hope this helps. Let me know if you have any other questions. The correct answer is D. Education. Article 21A of the Constitution of India provides the right to free and compulsory education to all children of the age of 6 to 14 years. It was inserted by the 86th Amendment Act of 2002. The Right of Children to Free and Compulsory Education, RTE, Act, 2009, was enacted to give effect to this right. The other rights mentioned are not covered by Article 21A. The right to work is guaranteed by Article 41 of the Constitution. The right to privacy is not explicitly mentioned in the Constitution, but it has been held by the Supreme Court to be a fundamental right. The right to equality is guaranteed by Article 14 of the Constitution. Therefore, Article 21A of the Constitution of India provides the right to education. I hope this helps. Let me know if you have any other questions. The correct answer is C. Right to equality. Article 17 of the Indian Constitution abolishes untouchability and its practice in any form. It states that untouchability is a social disability and its practice is forbidden. The enforcement of any disability arising out of untouchability is an offense punishable by law. The right to equality is guaranteed by Article 14 of the Constitution. It states that all persons are equal before the law and are entitled to equal protection of the laws. This right includes the prohibition of discrimination on grounds of religion, race, caste, sex, or place of birth. The right to freedom of religion is guaranteed by Article 25 of the Constitution. It states that all persons are equally entitled to freedom of conscience and the right to freely profess, practice, and propagate religion. The right to constitutional remedy is guaranteed by Article 32 of the Constitution. It states that every person has the right to move the Supreme Court for the enforcement of fundamental rights. The right against exploitation is guaranteed by Articles 23 and 24 of the Constitution. Article 23 prohibits forced labor and traffic in human beings. Article 24 prohibits the employment of children below the age of 14 years in factories, mines, or other hazardous occupations. Therefore, abolition of untouchability is a part of the right to equality. I hope this helps. Let me know if you have any other questions. The Directive Principles of State Policy, DPSP, were borrowed from the Constitution of Ireland. The makers of the Indian Constitution were influenced by the Irish nationalist movement, particularly the Irish Home Rule movement. Hence, the directive principles of the Indian Constitution have been greatly influenced by the directive principles of social policy in the Irish Constitution. The DPSP are not enforceable by the courts, but they are nevertheless important in guiding the actions of the government. They are intended to be a set of goals that the government should strive to achieve in order to create a just and equitable society. The directive principles include the following: promotion of social, economic, and political justice, equal pay for equal work, free and compulsory education for all children, protection of the environment, promotion of international peace and cooperation. The DPSP have been criticized for being too vague and idealistic. However, they have also been praised for providing a framework for the government to achieve social and economic development. So the answer is D, Ireland.